Swayam Prabha. Digital India. Educated India.
Now, taking the discussion forward, friends, the most important aspect in our course is to decide in public administration, is the constitution supreme? I repeat, in public administration, is the constitution supreme? Now, to answer this question, I think one will have to take into consideration the most important case in the constitutional history of India called Indira Gandhi versus Raj Narayan, a case that was decided in 1975 by the Supreme Court of India. Now, why this case is important, like many of us know, this is a case of the national emergency that was declared by Prime Minister Mrs. Indira Gandhi. But this case probably tells you that, I think no person is above law. And the rule of law is very important. And the rule of constitutional law is paramount and most important in all circumstances and in all cases. This case is definitely a landmark case. It is for the first time in the history of independent India that the election of a prime minister was set aside. So it has many firsts to its own instance. It was also for the first time that a constitutional amendment was struck down by applying the doctrine of basic structure, which was pronounced in the Keshananda Bharati case. And it was also for the first time that the election laws were amended retrospectively to validate the nullified election of the prime minister. So, for all these purposes, this was very important. Now, the background of this case is so very important. We all know how emergency was imposed, but that's not the real problem over here. The real problem was what happened before that emergency was imposed, and what are the facts that actually resulted in the emergency being imposed, where a lot of national leaders were actually arrested and they couldn't actually take part in their regular parliamentary proceedings and hence violating parliamentary privileges. So, why the supremacy of the constitution has to be established, I think this case will definitely tell you that even the office of the prime minister is subservient to the principles of the constitution. Now, general elections were held on in 1971 for the 5th Lok Sabha, okay, where Mrs. Indira Gandhi, the then leader of the Indian National Congress, she was supposed to come to power, and she was supposed to get a majority in the parliament. Now, the parliament had 518 seats, and Mrs. Gandhi's party, the Indian National Congress, they won around 352 seats, which is almost like a majority or an absolute majority in the elections. Interestingly, you will notice that at that point of time, the opposition candidate to Mrs. Indira Gandhi was Raj Narayan. He was the leader of the Ram Manohar Loya SSP, and he stood against Mrs. Indira Gandhi in Rai Bareli in Uttar Pradesh. And Raj Narayan was actually very confident of defeating Mrs. Gandhi. And in that confidence of defeating Mrs. Gandhi, he had actually taken a victory march as well before the declaration of results. However, later he was disappointed because he couldn't succeed in the same. And the results went in favor of Mrs. Gandhi, and Raj Narayan, who was defeated and disappointed, decided to appeal to the court, and he requested that the court nullify the election of Mrs. Indira Gandhi. On what ground? So Raj Narayan accused Mrs. Indira Gandhi of adopting corrupt practices during her election campaign. This was a very serious allegation. And to substantiate that allegation, friends, what he did was he went to the Allahabad High Court, where he actually challenged this, and he said that Mrs. Gandhi had violated all the election code that was enshrined in the Representation of People's Act of 1951. It was alleged that in her election campaign, Mrs. Gandhi used almost all the government machinery including not only the government offices, the automobiles, or what we call as the cars, but also she used government offices to campaign for her elections. Uh, so interestingly, friends, the allegation was that a lot of people from the army, from the police, campaigned for Mrs. Indira Gandhi, and that is how she actually won the election. There were other allegations of corrupt practices because voters were actually lured to vote for Mrs. Gandhi because there was a lot of liquor that was distributed, blankets were distributed among voters, and hence there was kind of an undue influence that had been committed by Mrs. Indira Gandhi. And Raj Narayan says this is something that should be the basis of nullifying the election of Mrs. Indira Gandhi. Please note, by the time this petition was filed in 1971, Mrs. Gandhi had already been declared as, having won the Raebareli seat in Uttar Pradesh, and she had assumed to be the prime minister of the country, as being the leader of the democratic largest party that had won the Lok Sabha elections. So the Allahabad High Court declared that Mrs. Indira Gandhi's election to be void. They found that there is substance in the allegation of Raj Narayan. They found that corrupt practices had been used, and they said that this is an election of unfairness, and Mrs. Gandhi's election should be nullified. Interestingly, Mrs. Gandhi made an appeal to the Supreme Court of India, obviously, and by that time, Supreme Court was on vacation, and though she was granted a stay, there was uneasiness in the Indian National Congress. There was uneasiness with Mrs. Indira Gandhi as well. Now, at this point of time, you will notice that Mrs. Gandhi, probably fearing losing her seat of a member of parliament, thereby losing the leadership of the Indian National Congress, thereby losing to be the Prime Minister of the country, she brings in a constitutional amendment. Now, this is a very serious use and abuse and misuse of power that Mrs. Gandhi gets into. To protect her seat, she gets to pass the 39th constitutional amendment in the parliament. This 39th constitutional amendment introduced Article 392A, capital A of the Constitution. Now, Article 392A said that the election of the Prime Minister and the Speaker cannot be questioned in any court of law. Thereby, literally saying that whatever is going to be held by the Supreme Court cannot be done so, because the Parliament now has the supremacy, it has the sovereignty to determine which is the law of the land. And the law of the land right now with the constitutional amendment, please note, it's not an ordinary law, clearly says that the election of the Prime Minister and the Speaker cannot be questioned in any court of law. So this by the Prime Minister thought that this is how to protect my office. This is how I will do public administration, and I will decide what the Constitution can decide and what the Constitution cannot decide. So Article 392A was brought about by the 39th Amendment of the Constitution. However, this amendment to the Constitution in Article 392A said that if there is going to be any challenge, it will be only a challenge before a committee formed by the Parliament itself. So judicial review of elections, especially of the Prime Minister and the Speaker, was attempted to be barred by this constitutional amendment. And interestingly, friends, this constitutional amendment, the 39th constitutional amendment itself, got challenged for its validity before the Supreme Court of India. Interestingly, friends, at this point, between 1971 and 1973, came the Keshavananda Bharati case, which is also a case which is important. I'll come to that case slightly later, which laid down a very interesting doctrine, which is relevant in this case of Indira Gandhi versus the Raj Narayan, the case of the basic structure doctrine. See, what the Keshavananda Bharati case did was that it allowed Parliament to amend the Constitution, but said that this power is not an absolute power, right? When it comes to public policy, public administration, legislature's power is also going to be read along with its duty. It is a restricted power, it's not an absolute power. So you can amend, but you can't amend the entire Constitution. You can amend certain parts, but you will not be allowed to amend the basic structure of the Constitution. Now, at that point of time, One thing that was important is that while we say that power is subject to abuse, absolute power is subject to absolute abuse, right? And it is very important to look at the limitation of power in public administration. Confining the powers, limiting the powers, and performing the duties in public interest is very critical and important. In this case, it seemed to be that the prime minister at that point of time wanted to protect her seat, made a law that only protects her interest. And was it necessarily in public policy or public interest? That was a real question. And hence, the doctrine of basic structure very clearly limits the power of the parliament. Now, interestingly, friends, if you look at the Keshananda Bharti case in detail, it was important to see whether this 39th Amendment to the Constitution could or have been brought about, because 39th Amendment to the Constitution literally takes away the supremacy of the judiciary in terms of constitutional review. And I think the independentness and autonomous character of the judiciary is important to bring in public administration, or an accountable public administration, as the case may be. Now, in the Supreme Court, the 39th Constitutional Amendment being challenged, there are many issues over here. To be honest, the 39th Constitutional Amendment, even if it was brought by the Parliament, was not appropriately debated at all. What you would notice is that many of the leaders at that point of time were detained thanks to the emergency that was imposed. They couldn't take part in the debate. There was no adequate application of legislative mind. And taking judicial review out, as I told you previously, we were talking about whether judicial review can exist for the ninth schedule of the Constitution. That also right now the Supreme Court has said we will have the right to review. So I think the judicial review of legislative and administrative action is what is the public policy of the land. So while many opposition leaders could not take part, the vote in the Parliament for the 39th Constitutional Amendment was just merely a farce. And I think though both the houses did make this amendment, the president, just assented to such an amendment without even, applying his mind at that point of time. So what the court did hold is that the election of Mrs. Gandhi should be nullified. It was taken through corrupt practices, and the court also held that the 39th Constitutional Amendment is illegal, it is unconstitutional, and it should be struck down, because the judicial review of any such action should not be taken off, and this affects the basic structure of the Constitution. In fact, in the words of Justice Matthew, he said that Article 329A destroys the basic structure of the Constitution. The resolution of an election dispute should be adjudicated, and this is very important for the protection of the democracy. A healthy democracy can only function when there is possibility of free and fair elections. The impugned amendment destroys the possibility and therefore violates the basic structure of the Constitution, is what Justice Matthew had to say. So the senior Justice Chandrachud was also part of this. He added that this amendment violates Article 14 and it creates some kind of an inequality among the members who are elected. Like, for example, you say Prime Minister and Speaker election cannot be questioned or judicial review. That's an inequality that was introduced by this amendment. So I think Justice Khanna found that this amendment violates the norms of free and fair election, and this also affects the principles of natural justice, and therefore the 39th Constitutional Amendment has to be struck down as being violative of the Constitution. And they said that this are very, very important part of public administration in elections, in electing who is your representative. And to that extent, you will notice that this case clearly lays down the supremacy of the Constitution, supremacy of the judiciary, and why Constitution should be the guiding light for all kinds of administrative actions of all the three organs of the government. I think this case clearly reiterates that fact, in very clear terms. So it's a good case to decide the importance of the Constitution. It's a good case which actually goes on to state why the Prime Minister's office, though it's the most important, powerful office, remains to be bound by the principles of the Constitution, by the confines of the Constitution, which clearly has laid down democracy and democratic values as the touchstone of the Constitution of India. Why the Constitution of India is the guiding light of public administration and public policy? I think to substantiate this, the case of what we call as triple talaq is an important case to substantiate this point. In 2017, the Supreme Court decided this Saharaya Banu versus the Union of India, which to a larger extent prevents discrimination of women in marriage. The word public and administration, as I told you, to define what is public is definitely not what is private. Now, is talaq a private matter? And should we interfere with marriage as a private matter? To be honest, friends, marriage is definitely private. But interestingly, the aspects of marriage that affect an individual adversely or impact an individual negatively or infringe the right of an individual to dignity, interestingly, becomes a matter of public policy and public administration. To be honest, when we say public administration, it is about protecting rights. It is about preventing discrimination. It is about maintaining the dignity of an individual. That's precisely what public policy and public administration should attempt to do. And does the Constitution give you the guiding light for the same? To an extent, yes. Now, if you look at the triple talaq case, as it is popularly called as, Muslim law, or what we call as Mohammedan law, is also another personal law in India, like the Hindu law or the Christian law is. And you will notice that Mohammedan law governs the Sunnis and the Shias, and largely it's not codified. Now, when it's not codified, it lacks that kind of interpretation or judicial application of mind. But when law is not codified, it is something that happens through custom. And customary practices vary from state to state, from situation to situation, and customs face a lot of problems or challenges of ethical morality. And triple talaq in India developed due to such a kind of customary practice, and it was a means of giving divorce. It is called at times not triple talaq but talaq ke biddat, and as the name suggests, it is a form of divorce where a Muslim man pronounces talaq 3 times in one sitting, and if he does so, then the divorce is confirmed. Actually, talaq-e biddat or triple talaq, it is called, is different from talaq-e hasan and talaq-e hasan. And in talaq-e hasan and talaq-e hasan, there is actually a time between which each of these talaq is actually pronounced, which gives the husband a time to repent and decide and come back. But in triple talaq, once the third talaq is pronounced, it cannot be revoked or taken back. Now, in case the husband realizes his mistake or after he has pronounced triple talaq, the process of remarrying the same girl is actually very complicated. But more than it is complicated, it's actually quite humiliating because the condition is that the girl should marry some other person and get a divorce, and after a iddat period, only then she can remarry the same husband. This clearly looks to be quite a cruel practice that has been developed in India, and has it impacted many women per se, whose lives have been turned upside down by just the practice of this triple talaq. Now, triple talaq has been a controversial practice or a custom, and it has left Muslim women to a lot of abuse by the husbands, and this probably is one of the contributing factors to the declining socio-economic condition of women in India. First of all, Muslim women are not financially strong, and husbands tend to use this against them. Now, in the Saira Banu case, what happened was, interestingly, here was a lady. She actually was, married for nearly 15 years to a person called Rizwan Ahmed. Now, in 2016, she was divorced through the pronouncement of triple talaq. However, there is actually, interestingly, triple talaq also does not require any reason for giving of the talaq. She filed a writ petition in the Supreme Court challenging the constitutional validity of talaq-e-biddat along with the practice of polygamy. And she actually said this infringes the fundamental rights of women, especially it is in violation of Article 14, 15, 21, and 25. So you will notice how the Constitution is a very important document in ensuring that the administration is pro-people and pro-women as well. So a lot of organizations joined this petition, some were in for, some were in against, but the organizations that opposed, the judicial intervention on triple talaq said that this is an essential religious practice, and hence it is protected by Article 25, and hence the courts should not intervene in this particular matter. And hence, I think what the Supreme Court did was to form a constitutional bench for the same. And the constitutional bench wanted to see if triple talaq infringes on the fundamental rights guaranteed in the Constitution and should be held to be unconstitutional. I think overwhelmingly you will notice, there were many arguments that were brought about in the court of law, but I don't think that is important. What is important is that, the court said that, public order, morality and health are very important touchstones of the Indian Constitution and Indian public policy. Public order, morality and health. And hence, any right of religion that is granted, say, by Article 25 or anything else, is subject to public order, morality and health. So your right to religion is not going to be absolute in any sense. And what the court did find is that the form of triple talaq has no sanction from the Quran, and it's not mentioned in the holy books of the Muslim community. And triple talaq has been kind of an evil in theology, which has been banned in many countries already. And taking the shelter of this custom was something that was really a cruel practice. The most important judgment that comes is from Justice Nariman and Justice Uday Lalit, who had similar views, and they declared this triple talaq to be unconstitutional because they found that it was manifestly arbitrary in all nature and character. Justice Kurian Joseph, who also said that this lacks the sanction of the Quran, and hence once there is a lack of sanction from the Quran, there is no place for its practice at all. And he thought that it was bad in theology and cannot be good in the eyes of law. Justice Nariman and Justice Lalit opined that triple talaq was in a way by which the marital bonds can be broken and the whims of the husband, and the wife cannot do anything, and hence essentially this violates Article 14, and at no point of time we can hold this to be an essential religious practice and then protect it under the light of the religion. Following this judgment, you will notice that the government of India not only took this case and this judgment very seriously, they enacted a legislation which made triple talaq a punishable offence through what is known as the Muslim Women Protection of Right on Marriage Act of 2019. And you will notice that triple talaq has been declared void as well as illegal, and there is a punishment that can be awarded to a person who tries to divorce his wife through talaq-e-biddat, and they can be punished for 3 years of imprisonment. So this is very important because you will notice, friends, when there is a conflict between personal law and constitutional law, personal law that is made or attached with religion, personal law that is in relation to marriage, family, adoption, guardianship, or any other matters, and they are against the public order and morality of the state, then the personal law will have to give way to constitutional law, right? So your personal laws, which are not in consonance with the Constitution, have to forego, and such practices, such kind of customs, which actually infringe the dignity of women in marriage, have no place in India, and that is what has been done right now. And despite the controversy attached to this case, I think now it's quite a settled principle of law that anything that is not permissible by the Constitution or is arbitrary, unfair, and infringes the rights of women in particular, which has to be protected by the Constitution, then those have to be taken off. So I think this case also highlights the principle that the Constitution is supreme, and your personal practices, personal laws are have to be subservient to the Constitution of India.